Despite any arguments which may seek to rail against the postulates put forth in this video, I knew Jerry when he was at Wendy Correctional Facility in New York. He was one of the most prolific legal minds in the prison system. He knew the law better than Yale or Harvard taught lawyers. Most importantly, Jerry the Jew was able to make the distinction between what is illegal and permitted and what is legal and just morally wrong and counter-survival to civilized society. This video would be how I believe Jerry would argue some points of today's cases. Although Jerry was serving a life sentence when I met him, the true circumstances for his part in the crime he was originally sentenced to death for are in fact nebulous, and we may never know all that there is to know about this modern-day, little-known legend of prison folklore. Everyone with half a brain knows that our legal system is corrupt. It routinely incarcerates innocent men and women for de minimis offenses, while hardened professional criminals with political connections or dirt on politicians routinely walk away. From Wikipedia article, link in the description. Jerry Rosenberg, also known as Jerry the Jew, was born May 23, 1937 and died June 1, 2009, was an American convicted murderer. He was incarcerated for 46 years, longer than any other prisoner in New York State history. Rosenberg was sentenced to death for his involvement in a double homicide of 2 New York City police officers. His sentence was commuted to life in prison to be consistent with laws reducing the use of capital punishment in New York. Rosenberg went on to become the first New York State inmate to earn a law degree and in turn gave legal advice to several inmates, including the leaders of the Attica prison riot. A book was written about Rosenberg and his time in prison, which was adapted into a made-for-TV movie. Rosenberg was transferred to Wendy Correctional Facility in 1991, serving, among other positions within the prison, as a paralegal assistant for 3 years in the law library, teaching convicts legal strategies on how to file appeals for their cases. Number 1. The Law of Unintended Consequences. This law states that all human actions have effects, and that some of those effects cannot be reliably predicted or foreseen, and were not the original intent of the person who took or didn't take the action that caused the unintended negative effect. An example of a positive effect or consequence is that the habit of buying a lottery ticket every Friday, although losing 99.9% of the time, won the Mega Millions jackpot for you after 35 years of buying tickets. An example of a negative effect is that your daily jog through Central Park gets you mugged and killed or shot by a stray bullet that was not intended for you at all. The gist of the whole thing can be summarized by the well-known axiomatic proverb that states that the road to hell is often paved with good intentions. The intentions of a defendant in a criminal prosecution are often taken into consideration by the judge at sentencing if the defendant pleads or is found guilty. However, one cannot reliably know or determine intent if there is no evidence to support it. Provable good intentions will mitigate the severity of the offense in the eyes of the court and result in leniency or even release, while ill intent will aggravate or exacerbate the severity of the crime and result in a more severe sentence. Number 2. Fruit of the poisonous tree. This axiom of the law states that an action or any series of actions by law enforcement or the courts which is based on or commenced by illegally obtained evidence, such as warrantless searches, are irreversible error, and the case is dismissed with prejudice, with one exception. If the prosecution can show that the illegally obtained evidence would have eventually been found, then the argument for dismissing the case is moot. Fruit of the poisonous tree is applicable if evidence is planted by the police, or it can be shown, for example, that the arresting officers forged a suspect's signature on an incriminating statement. In such a case, not only would the case be dismissed, but the cops could be sued, they would lose their jobs, and any case they ever worked on that had similar circumstances could be called into question with an avalanche of 440 motions. Number 3. Felony murder. Felony murder is charged when a defendant, in the commission of a crime, for example a liquor store holdup, causes the death of someone even if that death did not result by the intent of the defendant. This is the law of unintended consequences. If during the commission of the crime, The store owner has a heart attack and collapses dead, or later dies in a hospital from his pre-existing heart problem, it is still murder in the eyes of the law. Any accomplices, such as a car driver that had no idea that his passenger, who as far as he knew was just going to get a six-pack, can be charged with felony murder, and the burden of proof is on him about his knowledge and his intent. Number 4. Testi-lying. This is a term coined by police who, it's true, routinely lie under oath in their sworn testimony in court. They also routinely lie to suspects who are questioned or interrogated, and that's legal. However, it is a crime for you to lie to police, and it is perjury if you lie in court. It should be immediately suspect to a jury that with all the cheap video equipment available, that a video of an interrogation of a defendant signing a confession, particularly one that is typed and not handwritten, is not available for the jury to examine. When cops lie, it's usually to cover up something they did wrong, such as beating, threatening, or intimidating a suspect, or coaching a witness to lie or pick a suspect out of a lineup. Example, Vincent Jenkins. Number 5. Intent follows the bullet. A criminal plans and robs a bank, and he sees a teller push a button to sound the alarm. He shoots his gun at the girl, but misses and kills a police officer who is responding to the call. The intent was to shoot the teller, but the crime followed the bullet. The crime just transformed itself from attempted murder of a bank teller, a felony that you could get parole for in, say, 20 years, to a case that in many states will get you a gurney and a needle or a ride on Old Sparky. The moral of the story is, don't rob banks. You never know where your bullets are going to end up. Just kidding, but don't rob banks. You'll get caught. Number 6. Victimless crimes. Now, Jerry and I would most certainly agree that this is a non sequitur. It does not follow. It is an oxymoron, a contradiction, and in all honesty is a phrase that should never ever be spoken, like saying Beetlejuice 3 times and expecting that nothing will happen. The question that should follow is, where is the crime if there are no victims? Or to rephrase, who was the crime committed against? There is no logical answer because the premise, the postulate that there can be a crime without a victim is absurd and preposterous. This phrase is most often used by drug dealers and users. The people who are victims of drug dealers are the addicts and their families and friends whose lives and livelihoods are destroyed and who die from drug abuse. We must also consider the thefts, burglaries, and muggings that are a direct result of the user's addiction and the fact that drug sale profits support CIA-backed terrorists. So who are the victims of these victimless crimes? All of us. Number 7. Inevitable discovery. This little-known axiom is the saving grace for an unlawful and warrantless search if the prosecutor can successfully prove that the crack pipe, drug stash, or murder weapon that police discovered illegally would have been found eventually. Jerry and I would both agree that whatever you're looking for, be it a murder weapon tossed down the sewer 10 miles from the crime scene, or the Holy Grail of Antioch, if you look for it long enough, then eventually you'll probably find it. Wasn't it Jesus Christ who was reported to have said, "Seek and ye shall find"? The question then becomes, how long would you have to look before you admit that you will never find whatever it is you're looking for, and your discovery becomes not so inevitable? Number 8. Continuing injury stops the toll on the statute of limitations. Most states have a statute of limitations, a law that says that a prosecutor must bring a case to bar within a certain amount of time after a crime is committed. This limitation is in place because of witnesses' fading recall, limited lifetimes of those involved, degradation of evidence, etc., all of which contribute to the unreliability and veracity of witnesses and affects the integrity of the prosecution's case. However, there are exceptions to the law, always a loophole somewhere. If the criminal is a fugitive who flees out of the state in which the crime was committed or otherwise living in hiding, this suspends the statute. Once the fugitive re-enters the state and has a chance of being apprehended, the statute clock resumes ticking. There is no statute of limitations by federal law on treason and sedition, espionage, kidnapping, and murder. Some states do not have a statute of limitations for arson, sex crimes against minor children, and financial crimes against the state. One thing that can be successfully argued that should stop the ticking clock of the statute is the unreported repetition of the same crime upon the same victim, or for a victim who has been threatened or otherwise incapacitated by the offender into not reporting the crime, or if the victim is a child or person who is or has been rendered silent by actions of the offender. If I was on the bench in such a case, I would suspend the statute retroactively to the first occurrence of the offense so that a lifelong wife-beater could be charged for a 30-year-old assault. Number 9. DNA evidence negates the purpose of the statute of limitations. When it comes to evidence of a crime being committed, there is no better impartial, unimpeachable, accurate, and practically infallible witness than the properly applied science of DNA technology. To any criminal, DNA evidence is the ultimate "I'm fucked" moment. DNA negates or should negate any hope of a plea bargain. DNA at a crime scene or on or in a victim's body is 100% assurance of a conviction. To hundreds of innocent convicts, DNA technology was a godsend, the science that proved what they have been asserting for decades, opening the prison doors for those who were railroaded while the real criminals got away. But criminals on the law's side of the bars can find the means to exploit this technology, as DNA evidence still requires the testimony of someone from the lab who performed the test to assert that the DNA of the suspect was the same recovered from the crime. Barring contamination of some sort or other degradation, DNA can be reliable for hundreds of years. DNA tests are so sensitive that microscopic amounts can still be relied upon as infallible. And so reliability of a witness, the primary reason for limiting the time in which a case must be prosecuted, is entirely negated when DNA samples match the accused with 1 chance in 100 trillion chance of error. Number 10. Crooked cops, prosecutors, or judges, once discovered, should serve 3 times the bids of those wrongfully convicted. The reason you don't see too many judges or lawyers in prison is that they have practically free rein to commit crimes known as judicial and qualified immunity. This error of the legal system is much too complex to cover in a video. And so I will refer you to my website at netfortruthUSA.com/abovethelaw.htm. I'll leave a link in the description. The immunity from civil lawsuits and criminal prosecution that these people have, whether they are crooked or not, is second only to diplomatic immunity, where a diplomat who murders in public with cameras and 100 witnesses cannot be arrested or prosecuted. But immunity against criminal prosecution and civil torts for all but the most flagrant and egregious and heinous acts is a travesty, and an end to it must be legislated, else there is no justice to be had in this constitutional republic. When an innocent person is sent to prison by those who knew he or she was innocent and maliciously lied and fabricated evidence and did whatever it took, they should, when discovered, serve 3 times the maximum sentence that the defendant would serve if convicted.